And we have still one speech from Alain Pilette, who is, I think, online. Yes, hello, Mr. Pilette, bonjour. On va tester la technique. Eh ben, c'est bon, on vous entend. Bonsoir, Monsieur Pilette.
Technology is working. We can hear Mr. Pilette. Alain Pilette, you have the floor. Thank you very much. Thank you all for inviting me to follow this conference from afar. I'm really sad not to have been able to join you physically in Cologne to give you this presentation, which is a kind of celebration for all the work that has been accomplished so far. I found the conference highly interesting, and the presentations we heard, the talks and the explanations about the work that has been done, that shows the various criteria to define was really useful. Thank you also for inviting me to speak at your conference as a representative of a European institution, and more specifically of the Council of the European Union. Just a few words about the Council for those for participants who don't really know the European institutions. The Council is an institution made up of the representatives of the member states, and within the Council there are various bodies or various one is the e-Justice Working Group that has been mentioned on several occasions during this conference, in particular by Jean-Raymond Lemaire, who represented the e-Justice. This group is responsible for the implementation of the e-Justice strategy and the action plan adopted by the Council every 5 years. So every 5 years, we define a strategy and an action plan that is updated regularly. And the working group is also responsible for the legislation on the digitization of justice, which is currently in the final stages of a negotiation between the European Parliament and the Council. The working group is pursuing the following objectives for European e-justice. I will mention them very briefly, and you'll see that you really fit in these objectives with your project. The first is access to information. Access to information, in particular through the e-Justice portal that includes major information on experts. So we have this e-Justice portal with search engines. That is what you're working on for practitioners and judicial authorities, and so the interconnection of registers. So that's exactly what you are doing, the same approach. And we need to know what and who to include in these registers, and who will be accepted and would be considered admissible. And then we also need a joint architecture, joint nomenclature for such a register to be able to interconnect these registers and to have a common search engine. So e-Justice strategy covers the period of 2018 to 2023, and it states that work should continue on closely involving legal practitioners who have a dual role, that of users of information from projects concerning the interconnection of registers or databases, and in some cases that of those responsible for implementing and managing these registers and databases. So again, we are exactly in the same philosophy, the same approach as you have. And we now have also a working group in charge of electronic communication in the field of justice. And the strategy states here that e-Justice should facilitate electronic interaction and communication between judicial authorities as well as with citizens and practitioners. And this in the framework of, in the course of judicial proceedings, for example, by means of video conferences or secure electronic data exchange. And this by setting up a community of experts and also agreeing on the major functions and criteria of experts, about quality of experts, the quality criteria for experts, for example, and also by setting up and establishing these registers. And when we create a search engine, a common search engine, this is really in the same spirit. And the third objective is the interconnection and interoperability of member states' systems. And this is, again, exactly what you're working on. And as you've understood, we do not want to have only one national register or a regional or a European registers that are compatible. We need to make sure that these can be interconnected and interoperable. And it concerns not only the content, but also ethics, competences. So it's, again, exactly what you've been working on within your project and what you've been discussing this morning and this afternoon. The e-justice strategy for 2018-23 emphasizes cooperation with practitioners in 3 terms. I quote, projects proposed or managed by practitioners and/or in which practitioners participate should be eligible for inclusion in the action plan if they meet the requirements set out in the previous 3 points. So the previous points are the objectives I've just mentioned. Projects proposed by practitioners will be initiated by them. Yes, so that's on your initiative that this project has been launched, and it is understood that not all member states will be in a position to assist in the implementation of these projects due to the differences in national systems. Practitioners should be involved in the implementation of the action plan as advisors or partners in projects which rely on their participation or which could benefit from it. So here you see in this last sentence that member states are really very cautious, and this is why I invite you to maintain contact with us. Jean-Raymond is already doing it on a regular basis, and I really appreciate his work and what he's doing, because it is essential to have member states participating in projects. And the e-justice strategy indicates that not all will be able to implement or contribute, but if some can do it, they should do, and they should be able to do it and contribute to your project. And that would be already something to bring the results forward. The e-justice strategy is accompanied by an action plan covering the same period, and this includes your project to create national directories or registers of judicial experts and to implement a search tool on the European e-justice portal interconnecting these directories. I am pleased to note, after listening to your conference today, that the progress made on your project is very impressive. I am impressed by the work accomplished by an institute and Euro experts. I am aware of the scale of the task and that you are tackling, and I'm convinced, and I admire your ambition in converging the national registers in terms of qualification criteria, the standards expected of the bodies responsible for registration, and the procedures for registering and deregistering experts from the registers is already a major challenge, and this was the topic at the beginning of your conference. This need for convergence must be pursued with the central objective of strengthening and consolidating mutual trust between experts from different countries, and also between judges and prosecutors from the different member states. So this is one key objective we must always keep in mind. So this was one major topic during your conference, and there were many discussions about this, but we must be aware of not being too radical in our approach with regard to standards, not to adopt an approach that would be too constraining. And this morning we talked about disciplinary measures, for example. And again, what I repeat here, important here is to establish trust between member states. And we should facilitate the search for an expert and the nomination of or the appointment of an expert from different member states in all fields of expertise, in all professions. Everywhere we have people who are more or less competent. So that would be the same for experts. I think we must make the difference between a standard for registration in a register with certain rules that could be defined by the national authorities, as long as they meet with certain criteria, but we mustn't be very restrictive and apply the same criteria everywhere. Now, with regard to the disciplinary approach, when what has been mentioned, discussed this morning, it seems to me that in the professions that are regulated, the disciplinary measures cover cases when the behavior is unlawful and not about the expertise of the professional. Another longer-term objective is the interoperability, so that a European search engine can eventually be grafted onto a national or regional search engine. This has been discussed also previously today. We meant one single register per member state or several registers in member states. What counts here is to have a common nomenclature. Now, whether you have one or several registers in one member state doesn't really matter. It doesn't make much difference as long as you have a nomenclature that allows the connection to a single search engine. So here again, we mean to target interoperability more than the integration into a single engine or register. So that has been mentioned this afternoon. We need to establish convergent nomenclatures with identical categories and subcategories in all member states for this. It is essential. We also have specialties, languages. It is all very complex, but we cannot avoid going through these steps. And we can also get some inspiration from some national registers that already exist. We have a register for the mediators, for example. In Austria, there is a search engine for mediators, or Find a Lawyer that has been mentioned, which has the same approach as yours. And as Jean-Raymond said, equally, we are not talking about professions, so it is more difficult, but it's even more admirable to undertake such a task. And finally, we need to add an IT tool that will enable us to search for an expert and update the lists of experts easily. Why is that important? Well, because we need the expert profession to be established at the European level, and also in the context of digitization of legal proceedings at European level. What I mentioned at the beginning of my presentation or my talk, with a regulation and a directive. For this, it is important that experts organize themselves in such a way as to be able to strengthen their contribution to the efficiency of justice, to be able to contribute to the justice that will be digitized. We have the creation of directories and establishment of identification and authentication procedures that will make it easier for experts to connect to electronic communication and video conferencing systems. Once you need to be accredited to be identified as an expert and to participate online to legal proceedings, you need a register. It is indispensable if you want to be able to connect. So you started with you're starting with 6 pilot countries and a search engine. I think this method is the correct one. You have adopted it in many projects. And you also have the e-Codex project with the technology that will be used for the digitization of justice. And things have already started, been initiated. And in any case, we have limited groups of member states that start piloting a project, and then the project extends to other countries. So thank you again for inviting me at your conference. For us, dialogue and exchanges with practitioners from the field are absolutely invaluable, because we are more part of where we like field experience at the European level. So we need contact and exchanges with practitioners from the field, as I was saying. Users of the tools and solutions developed at the European level. You will help and contribute to develop them, will need you to develop them. That is why I encourage you to maintain a dialogue with us, definitely, and to take also this opportunity to tell us what you expect, to tell the member states what you expect from them, so that we can help you in your efforts. We meet in the e-justice working group, and so you can tell us what you need in a meeting, for example, with the e-justice working groups. You can present the progress made by your project, what you expect from the member states, and perhaps also raise some questions. For example, if they want to include translators and interpreters to the expert group, or any other question you want to discuss directly with the member states. This needs to be prepared, of course. Member states need to be informed about the issues at stake and be prepared to the questions you might raise, so that the representatives from the member states who are not all knowledge on every issue might prepare themselves to reply to your questions. Another point, I have another question. You said that you were going to address some recommendations to the Commission. Here you need to be clear about your explanations. I do not think that the European Union will decide and adopt any legislation or regulation on an expert directory or register. But it might take more into consideration registers, experts, and how these can be used and how this can work at the European level in a justice system. This seems more realistic and also legitimate, and it could be very useful to collaborate with the CEPEJ work. We have the CEPEJ president with you. He is also a member of your jury. So you could also have, well, you have the annual meeting of the CEPEJ with some information that also feed in the justice portal of the European Union. So from this point of view, the European Union collaborates already very closely with CEPEJ. And the only mention of experts on this in this collaboration is to hear them through technology. And I mentioned digitization before, with the digitization of expert registers, so that they also have the possibility to connect online. But we could develop this use in this
la visibilité.
Scorecard, in this scorecard, European scorecard, justice scorecard. And we also have magistrates, lawyers. We need experts. For the magistrates, who, well, these need to be able to find the right experts in a different country from the one they are practicing, and they need an improvement, well, for an improvement of the quality of justice through the improvement of the quality of experts appointed to a case or to proceedings. And this morning you mentioned the criteria for registration of experts, of the updating of the information. All this is not in the scorecard at present. I cannot commit or take any commitment in the name of the Commission, of course not. But the citizens are using the justice scorecards, so perhaps this information you have could be useful. So now you want to provide quality expertise at the European level, and for this I'm very grateful to you. I'm very grateful for inviting me and allowing me to listen to your debates and also to talk to you at the end of your conference. And I hope we will keep in touch and maintain the dialogue. Thank you very much.